when should I dissolve my entity after a foreclosure has occurred? Got another hot topic to talk about today. Given the volatility in the capital markets that we're seeing continue, right? We saw the Fed raise interest rates at a historic pace. Many of you know that, unless you've been living under a rock for the last few years. That started in March of 2022. And so as a result, that put downward pressure on a lot of loans, especially those floating rate loans that are tied to SOFR or LIBOR, and LIBOR when it was changing over to SOFR. Those sorts of floating rate debt products that are in connection with certain asset classes, multifamily, self-storage, mobile home parks, all of those, that interest rate, volatility of the interest rate resulted in significant pressure, such that when lenders start to foreclose on assets, right? Many of you are aware that there is a maturity wall that is about to occur with many bridge lenders across the country. What does that mean when you say a maturity wall? Well, the reality is most of these loans were bridge loans. That means a shortened period of time. They were meant to get you to a permanent loan like a Freddie Mac or a Fannie Mae loan product or even a HUD loan product. And so what the Fed asked in June of 2023 with a bunch of bridge lenders and the market makers and people that had significant kind of like thought leadership was essentially extend and pretend. Pretend as if the loans are performing. Don't create another 2008 scenario. Extend out the loan maturity dates on those and basically enter into modification agreements that are with an otherwise credit-worthy borrower, which many, to their credit, many bridge lenders did. And so now what we're seeing is that the appetite for bridge lenders to extend again those loans that have already been extended under this modification encouragement from the Fed are pushing back some. And so as a result, there's going to be some foreclosures that do occur. Now, is it going to be like a bloodbath like 2008? In our opinion, no. And most experts in the space of commercial real estate are saying it's not going to be like 2008, where we had a cash problem. Here we have a valuation problem. That means that the basis within which buyers bought into these asset classes was too high, given the types of rents that are being collected at those properties and the volatility in the interest rates and the insurance market and the hedge market for rate caps being still volatile. The reality is the revenue is insufficient to cover the current debt service. That means that gives lenders essentially a couple choices. Do I foreclose or do I allow another extension to exist? So here's the hot topic. All this is leading up to the hot topic. The question that we get asked by a lot of clients and even potential clients is, when should I dissolve my entity after a foreclosure has occurred? So in a hypothetical situation, the lender comes in, forecloses on the asset. You as the borrower, operator, syndicator, sponsor cannot get another extension or modification into place. You can't get a forced sale into place. You can't otherwise dispose of the asset and protect equity, and the lender forecloses. A lot of people are saying, should I just terminate the entity now? And the reality is maybe not too fast. Why? Because there is this concept out there that basically says that if you, the operator, sponsor, the manager, whether it's a limited liability company or a corporation, you, that control group, the control group of that particular entity, if you know of some debts and obligations of the company itself and you decide to terminate or wind down the company without providing notice to those potential judgment creditors, you could be personally liable. What are you saying? Are you saying that the people, the individual control parties, could be potentially personally liable if they shut a company down without notifying potential judgment creditors, even if that company doesn't have assets to essentially satisfy those very debts and obligations that the potential judgment creditors are looking for? And the answer is yes. It largely depends on which state you're in, but regardless of the state, the best practices are essentially notifying all potential judgment creditors, that means potential vendors, lien holders, even if they're unrecorded liens, of the concept that you're about ready to dissolve or wind down the company. And the reason, the public policy behind this is such that states want to provide a way for judgment creditors or potential judgment creditors, those are the people whose money is owed to, the ability to say something before the entity is dissolved. And so remember, the entities serve multiple functions, but one of the most important functions that they serve is asset protection. It provides a corporate shield of protection between you as the owners of that asset or the control parties and the outside world. So if you're to close down an entity without essentially paying any attention to the debts or obligations that might be owed by that entity, and you know about it, you could potentially be subject to personal liability. It's not a yes or a no immediately. And if you're in this situation, you should reach out and talk to your specific lawyer about that. But a couple factors affecting liability. One is awareness of potential claims, right? We talked about this, the possibility of actual potential claims out there, and then in secret, essentially closing down an entity without notifying those people. Proper dissolution and winding up, that means documenting the reasons for winding up the corporation or the entity itself, and then doing it legally. Personal guarantees. Many in the even in non-recourse floating rate loans, you tied yourself to essentially guarantees. So remember, those guarantees still kind of exist out there. And some of you might even have loans that have covenants that require the entity to be in good standing, and that exists even post foreclosure. There are statutes of limitations that exist in every state where your loan is based, or the asset that was bought or in that particular loan. So you want to pay careful attention to that. So the reality is there are lots and lots of issues that are tied up. If you're somebody that's thinking about potentially winding down an entity because the asset that maybe it was the only asset for the entity and it's been foreclosed on, just remember there are lots of sticky little tricky little issues that attach themselves in that thing. So hopefully this was helpful for you. If you have an issue like this, please reach out and speak with your attorney. If you're looking for an attorney and you want to reach our office for a consultation, please do so. In the meantime, if you love commercial real estate like we love commercial real estate and you're looking for deals, happy hunting and Godspeed.